Hey everyone, let's dive right into today's explainer. We are unpacking a highly specific and honestly fascinating legal dispute centered right in the heart of Maharashtra's real estate landscape, the Pagdi tenancy system. Now, if you aren't familiar with the nuances of property law in this region, it might seem like just another landlord-tenant disagreement. But the stakes here are incredibly high. We're talking about generational homes, massive financial investments, and a real clash between procedural courtroom law and statutory rights. Today, we're going to analyze a specific awareness initiative to understand exactly what is happening on the ground. And while this is very specific to Maharashtra, the tension between rigid procedural rules and fundamental human housing rights is something that resonates absolutely anywhere. To really grasp the urgency here, we are looking at a targeted campaign organized by a group called the Pagdi Sangh. They're loudly sounding the alarm that generations of tenants are currently facing the imminent threat of what they call free evictions. Basically, that means people are facing being forced out of their long-term homes or commercial spaces without a single dime in financial compensation. They're highlighting that folks who have lived somewhere for decades with assumed legal protection are suddenly finding themselves incredibly vulnerable. So here's how we're going to break this all down today. First, the Pagdi housing dispute itself. Second, we'll decode Section 56. Third, we'll look at the ignored law. And finally, their demands for justice. Let's get right into it. Part 1, the Pagdi housing dispute and understanding the actual stakes. According to the campaign materials we're reviewing, there is a massive misconception that needs to be cleared up right out of the gate. Pagdi isn't just your standard month-to-month renting. Not at all. Under the system, tenants actually pay huge, sometimes full market value premiums up front just to get the keys to these premises. Because of that massive initial financial outlay, the tenancy transforms into a highly valuable, legally acquired right. These tenants aren't just passing through, they've bought into the property in a very real monetary sense. Because of that huge initial investment, the initiative firmly rejects the idea that these evictions are just an unfortunate side effect of a changing city. Instead, they characterize them as a profound legal injustice, straight-up economic exploitation, and a severe violation of tenant rights. They are framing the tenants not as disposable occupants, but as deeply vested financial stakeholders. Moving on to Part 2, decoding Section 56 and the legal framework. The campaign points straight to the Maharashtra Rent Control Act of 1999, specifically Section 56, and highlights a very intentional balancing act in the law. On one hand, Section 56I explicitly recognizes that tenants hold transferable rights that carry real market value. But flip to the other side, and Section 56I guarantees that landlords get a statutory share of those transfer premiums. So the law itself acknowledges that it's not a one-way street. Both parties have a legally recognized financial interest here. So by treating these tenancy rights essentially as property rights, the campaign is arguing that this financial interest is a real, tangible asset. It's a valuable financial interest that they argue simply cannot be ignored or destroyed by the courts. Think about it. If the law says the tenancy has market value, then extinguishing that tenancy with a simple eviction decree effectively wipes out a massive financial asset belonging to the tenant. Which brings us to Part 3, the ignored law, and the core grievance of this whole dispute. Here is where the campaign makes a truly shocking claim. Over 25 years. They boldly assert that Section 56 has been effectively ignored by the courts for more than a quarter of a century. That is 25 years where, according to this initiative, the legal protections written in black and white have simply not materialized in the real world, leaving countless families in a state of perpetual housing uncertainty. They highlight a really sharp contrast here to explain how this happens. They point out the judicial excuse, which is often that Section 56 wasn't explicitly pleaded, meaning defense lawyers didn't specifically write it into their arguments. They contrast that excuse against their view of the actual law, which they argue is mandatory and automatic. Basically, they're saying a judge absolutely must apply it, whether a lawyer remembered to jot it down or not. There's this incredibly powerful quote from their campaign that really drives this home. Ignoring mandatory law is not an error, it is injustice. They're forcefully arguing that your fundamental legal rights and essentially your life savings tied up in a home shouldn't vanish just because of a lawyer's drafting mistake. They view bypassing these statutory rights as sheer judicial negligence. So, Rather than just pointing out the problem, the initiative actually built a framework to challenge it directly. They've put together 5 critical questions, think of it as a mandatory checklist, that they insist every single judge needs to answer before even thinking about handing down an eviction decree against a Pagdi tenant. Let's run through this checklist together. First, did the tenant pay Pagdi? If yes, then does the law recognize its value? Again, under Section 56, the answer is yes. Then comes the crucial pivot. Upon eviction, where exactly does that value go? And finally, is the tenant receiving lawful compensation? They are basically telling the courts to follow the money. You just can't make a legally recognized financial asset disappear into thin air. All right, our final section, Part 4, demands for justice and the path forward. The campaign draws a really hard line in the sand here. Their baseline is that there must be absolutely 0 free evictions of Pagdi tenants. None. If a landlord wants a tenant out, they argue it cannot happen without fair rehabilitation or fair compensation. Just handing over an eviction notice and walking away is, in their eyes, entirely off the table now. So what does fair actually mean to them? Well, they lay out 2 very strict alternative conditions. Option 1, the landlord provides alternate premises, but it has to be the exact same size and in the exact same locality. No downgrades. If that's not possible, then option 2, pay the full current monetary market value in cash, which has to include any future redevelopment benefits. It's definitely a high bar, designed to ensure that tenants' acquired financial rights are fully respected. But you know, the ultimate endgame for this campaign goes way beyond fighting individual cases in court. Their biggest overarching plea is actually to the government itself. They're pushing the government to step in and completely convert the Pagdi tenancy system into outright ownership. They essentially want to erase the tenant label entirely for these long-term occupants. And how do they justify such a massive shift in property rights? Well, they look right back at the history we've been discussing. They cite those massive upfront premiums paid generations ago. They highlight that it's the tenants who have physically maintained and preserved these buildings for decades. And fundamentally, they argue that these families have contributed hugely to the city's overall growth and property value. They believe that kind of deep, multi-generational investment straight up earns you the right to ownership. And that leaves us with a really compelling final thought to wrap up this explainer. On one side, we have clear statutory law, and on the other, super strict courtroom procedures. Will the legal system ultimately be able to bridge this gap between technical pleadings and the mandatory statutory rights of these tenants? It's a massive question about how our justice system balances rigid rules against the very real human stakes of housing security and generational wealth. For sure, it's something anyone interested in property law should be watching very closely.